It was all about recognizing a fetus as a separate and distinct human being with their own rights. Now that Roe has been reversed, how does the concept of fetal personhood play out outside of the procedure room? For more on that, we turn to Michelle Trigger of Trigger Law. Good morning to you.
Good morning. Thank you for having me.
So just 4 days after the Supreme Court overturned Roe v. Wade, a Plano, Texas woman was cited by deputies for driving alone in the HOV lane. Brandy Batone is contesting her $215 ticket, saying her then unborn baby girl is a person, according to the high court. Prior to the June ruling, Texas kind of led the country off with the most restrictive abortion law at that time, the heartbeat law. And a fetus is a person there in the penal code, but not the transportation code. Help us with this.
So when this happened, I actually had to chuckle because this was very clever on this woman's part. The Roe v. Wade decision does not necessarily focus on a person as much as viability. So that was probably going to be the turning point for her. The transportation code was not speaking towards viability. It was speaking towards a person in the sense of a physical presence within the vehicle. So unfortunately, while clever, I don't think that Roe v. Wade is going to help her with the traffic ticket, because again, the ticket is looking as to whether or not there are two people physically present in the vehicle for this purpose, not necessarily whether there is a person and a viability sort of person in the vehicle. So I don't think it's going to work, but absolutely clever decision to argue that on her part.
And coincidentally, her hearings about this ticket have been delayed since she's made this claim. So that's something we're still following. Well, here's another one. As relationships unfortunately dissolve, child support can be a very contentious issue. If a fetus is considered a person by some at 6 weeks gestation, can child support start then?
As of yet, no. Although I will say that in child support court, they do allow an argument that there can be pregnancy costs that are incurred, which a father can be responsible for paying. So for example, when I'm in family court, I often file motions where we assert that the child is on the way and there's pregnancy costs. There are appointments that incur different types of medical fees. And we're generally very successful, and it's legal to recover those costs. So I don't think it's necessarily a far reach, but as of yet, the way that the child support laws are written, they are specifically written post-birth. Again, not viability, but birth. So that could change, and Roe v. Wade being overturned could certainly affect that. But as of yet, most of the child support laws do turn on post-birth language as opposed to viability.
Alrighty. Illegal immigration, another contentious issue in this country. We know special allowances made for children brought here through no fault of their own by their parents. We also know that children born here are U.S. citizens regardless of their parent status. But what about the issue of deportation in this post-Roe environment? Some believe mom shouldn't be deported if she's carrying a U.S. citizen fully endowed with all the rights of any other person.
So again, a very good point, and these are all going to be questions that are going to be revisited, I have no doubt. But as of now, with a deportation, again, most laws that are regarding citizenship are post-birth. So you'll read most language is going to focus on someone being born in the United States, not being viable in the United States. So until we see an actual change of language towards viability as opposed to birth, we're probably not going to see a change in these type of circumstances. But it's not far off to say that there could be, because again, now that we have a decision indicating, to put it very simply, that this fetus is a person, anytime we see language that references a person as opposed to a birth, I think is absolutely going to be fair game.
Alrighty, well, it may be fair game in this next scenario as well. Millions have complained about the Texas heartbeat law and the other very restrictive abortion laws in place now around the country because they ban the procedure before a woman may know that she's pregnant. Pivoting on that same 6-week time frame, if that fetus is a person at 6 weeks, could mom and dad take out, let's say, an insurance policy on them and then collect in the unfortunate circumstance that there is a miscarriage?
Again, another great point, because all of these situations, we are used to turning on whether or not somebody is a person. Maybe even if we simplify the language, we say, look, we're insuring a person when we're insuring a life insurance policy. We have to look to the language. So if the language says person, I think that it's fair that you could argue that. With that being said, most insurance policies are going to probably be a little more savvy than that, and they're going to dictate, for example, an age. And that's going to be problematic because an age is not going to technically start until birth starts. So it's going to be very important to look at the language in these types of situations. I think that insuring a fetus would be very difficult because, again, generally a standard life insurance policy, for example, is going to ask for a date of birth. That is not something that has yet happened. It's going to ask for a name, which, while the parents may have a name in mind, we're not going to have a registered name or a birth certificate to provide. So likely you're not going to be able to successfully insure, for example, an unborn fetus.
Alrighty, thank you so much for your insight this morning. And as with all the individual states working on their own abortion laws right now, you've pointed to language several times. We may run into a situation where the language gets to be very different in every state, where person is used in some and birth is used in others. Michelle Trigger, thank you so much this morning.
Thank you so much.